right, ladies and gentlemen, we'll now move on to chapter 10. Sorry, it's a cigar lounge, so I'm trying to smoke and teach. But we're talking about chapter 10, the exclusionary rule and entrapment. So let's go ahead and jump in. As an introduction, historically, federal agents and state police who engaged in unreasonable searches and seizures were subject to civil suit by the victim for the return of property or damage, or whether the subject to criminal prosecution as or were subject to criminal prosecution as to disciplinary procedures. In 1914, in the Weeks case, Weeks v. United States, the United States Supreme Court ruled that the 14th Amendment required that evidence seized in violation of the amendment was to be excluded from evidence in federal courts, but only federal courts. So that means only when federal law enforcement did something against the rules. The Weeks case said that it would be excluded in federal proceedings. So later on in 1961, so you're talking roughly at least 37 years later, no, 47 years later, in Mapp v. Ohio, that's Mapp, MAPP versus Ohio, the Supreme Court extended the exclusionary rule to the criminal trials in state and local courts. So it made it apply to everyone. So the entrapment defense can be, and also the entrapment defense, and this is another part of the chapter that we'll talk about, can be used by defendants who can demonstrate that a government agent induced them to commit a crime. We'll get to that later. So let's talk about the exclusionary rule and what it means. In Weeks v. United States, the court held that evidence seized in a search that violated the Fourth Amendment, is excluded from use as evidence in federal courts. And I'll go back. I think in the introduction I said 14th. I meant fourth. I'm sorry, I misread that. So we're talking about the Fourth Amendment right now. But in the Weeks case, if there was evidence that was seized in violation of the Fourth Amendment, it was excluded from use as evidence against the defendant in federal court only. Um, then in Wolf v. Colorado, the United States Supreme Court held that the requirements of the Fourth Amendment are incorporated into the 14th Amendment and are thus applicable to the states. So before that time, of course, you had what we call the Silver Platter Doctrine. This was declared unconstitutional in 1960 in Elkins v. United States. But this involved federal officials evading requirements of the Fourth Amendment exclusionary rule by introducing the evidence at trial that had been seized by state officials in violation of the Fourth Amendment. So we talked during the whole course about how the cat and mouse game is not really between criminals and the good guys and the bad guys. Sometimes it's between the good guys, the cops, and the system. So they want to find a way to circumvent these rules. So if you want to get around the Fourth Amendment, they play the cat and mouse game of trying to figure out how to get evidence in uh, without being subject to any rules. So if the Weeks case said that federal law enforcement couldn't use any evidence against a person in federal court if they were had violated the law, what was happening was now the federal law enforcement they were using local law enforcement to retrieve evidence illegally, and then when they got to court, they were saying, "Hey, we didn't break the law. The state court did, or the state official did, so therefore it should be used." So of course that was a way they were kind of circumventing the rule, and the court saw straight through that. So of course in 1961 in Mapp v. Ohio, the United States Supreme Court held that the Fourth Amendment exclusionary rule extended to the states and local law enforcement as well. So that means whether it be the Greensboro Police or the federal marshal, the federal marshal, um, if they violated your Fourth Amendment right, then no matter what type of case it was, that evidence was excluded. Um, of course, debating the exclusionary rule. There are several justifications for the exclusionary rule. First, the failure to exclude evidence seized as a result of an unreasonable search undermines the Fourth Amendment. So, right? In other words, why do we have the Fourth Amendment if we're not going to apply it? It doesn't have it won't stick if we don't do that. Um, Okay, but it undermines the Fourth Amendment prohibition on unreasonable searches and seizures. In other words, there would be no true, what I call it, incentive for police to actually do it the right way. The exclusionary rule also deters the police from carrying out illegal searches and seizures and safeguards the integrity of the courts. The threat of the exclusion of evidence has led to an increased police attention to the law, search and seizure. And studies indicate um, that the exclusionary rule is invoked in a limited number of cases and has not significantly impeded criminal prosecutions. And I can say that myself as an attorney. Uh, Here and there, the Fourth Amendment will come up where we have to make it an issue. But for the most part, most of the cases fall under some exception to the Fourth Amendment rule. So usually we don't have a leg to stand on in Fourth Amendment challenges. So very seldom, does this happen. So some would argue that means none of the evidence is going to get in and the bad guys are going to get away. But that's not what's happening at all. Um, the exclusionary rule has been criticized for failing to deter unlawful searches and seizures and for resulting in the exclusion of reliable evidence from trial. The exclusionary rule imposes the cost of an unlawful search on society by impeding criminal prosecutions rather than on police officer who is reasonable, responsible for the unlawful search. A search that violates the Fourth Amendment also results in the exclusion of evidence, whether the constitutional violation is modest or significant. So that's what most people say. But what I would say to that is one thing about these cases. Let's say even if there is a drug bust and they bust in and they violate the Fourth Amendment and they end up confiscating a whole bunch of dope, even though they can't use the evidence against the defendant because they violated his rights, guess what? It's not like the court say, "Or you get the dope back." No, the dope is gone. So it still works. So essentially, the cops still get bad stuff off the streets and guns and stuff like that and contraband out of people's hands. It just can't be used against them in the court of law. So it doesn't mean the cops don't. There's not a win in there somewhere. So there's still a win. Let's see. A number of alternatives to the exclusionary rule have been proposed, such as civil suits, criminal prosecutions, civilian review boards, and in what we call internal administrative procedures. But the exclusionary rule is what the law is. And it's not used that much. You'd be surprised. So it's still a good law. It's not really impeding or stopping law enforcement from doing their job. It's just a rule they have to follow. We all have rules we have to follow. They should too. Um, Invoking the exclusionary rule. The reasonableness of a search and seizure may be challenged by filing a pretrial motion to suppress. Um, and you saw that in that's in one of your right hypotheticals, the motion to suppress. And honestly, in all my right hypotheticals for criminal procedure, there's always a motion to suppress, and you have to figure out whether or not law enforcement violated or didn't violate a constitutional right. So most state and federal courts place the burden of proof on the defendant when the search or seizure is based on a warrant. So, of course, if they come in with a warrant, that means we've already been to a judge and we've already been cleared. We can be here. So, at that point, if the defendant is going to challenge a warrant, of course, the burden is on the defendant now to prove that the basis of the warrant is wrong and it shouldn't have been issued. The burden is placed on the prosecution when the police act without a warrant. So the police act without a warrant. We filed a motion to suppress, and it's all up to the prosecution to show um, that what they were doing did not violate a right. The defense may appeal following a criminal conviction on the grounds that the judge was in error when admitting the evidence at trial. In contrast, the prosecution is required to appeal a decision to admit the evidence immediately after a pretrial motion. So what that means is now there's something else that we don't really go over, but it's called double jeopardy. So once a person's trial is started, that means jeopardy has attached. Once the jury's impaneled and we start presenting evidence, that means you technically can't try me after you. So if the prosecutor loses the trial, they can't go back and appeal and say we want to try them again. They only get one chance. So what that means is if there's a pretrial motion that's made to keep evidence out, and let's say they lose the motion, meaning that the evidence now goes out, that the prosecution has to appeal right then. If they feel like the evidence shouldn't have been gone out, they have to file their appeal right then before trial. Um, so the defendant, on the other hand, can either appeal right there, I mean, can either file an appeal of that motion right there, or they can wait to see how the trial goes, to see if they win or lose, and then file it. But so of course the prosecution has less options because of the rule of double jeopardy. Um, let's see, a defendant who has exhausted his or her state court of appeals rights and has unsuccessfully in is has been unsuccessful in overturning his or her convictions may file a writ or of habeas corpus, or possibly even take it all the way to the Supreme Court if the United States Supreme Court, if they accept. Standing. Who has stand? What standing means is, am I in a position to invoke the right or bring the motion to suppress? A defendant has standing to challenge the introduction of evidence that is obtained through the violation of his or her personal Fourth Amendment rights. The legal test to be applied for standing in the case of an alleged violation of Fourth Amendment prohibition on unreasonable search and seizures is whether the defendant has a subjective, that means personal, and objective, meaning reasonable, expectation of privacy in the area that is subject to the search. The burden of proof customarily is placed on the defendant. So what that means is, just like the Nino Brown case that we had talked about earlier. In that case, if both Nino and Mitch had a reasonable expectation of privacy in the area that was being searched. Yes, it was Nino's house, but Mitch was in the house. So by them busting in, he had a reasonable expectation of privacy of what they were searching, because he was in the house. But definitely we know for certain that Nino had standing because it was his house. Um, so exceptions to the exclusionary rule. Um, the United States Supreme Court in 1973 in United States v. Calandra held that the exclusionary rule is a judge-made remedy whose primary purpose is to deter unreasonable searches and seizures. The court adopted a balancing approach that resulted in the recognition of exceptions to the exclusionary rule in those instances in which judges conclude that excluding the evidence would have little deterrent impact on the police, and that this modest benefit is outweighed by the social cost of excluding the evidence from trial. These exceptions include collateral proceedings, attenuation, good faith, independent source, inevitable discovery, and impeachment. Does the exclusionary rule deter unreasonable searches and seizures? I say it does, personally. A number of scholars have studied whether the exclusionary rule deters unconstitutional searches and seizures. Researchers have concluded that it is virtually impossible to answer the question of whether fewer unlawful searches have occurred as a result of the exclusionary rule. Studies also indicate that the police, prosecutors, and judges dismiss relatively few cases because of the exclusionary rule. So honestly, the exclusionary rule is there, but it doesn't mean that every case is getting dismissed. As a matter of fact, in my career, very seldom do I even have exclusionary rule issues when it comes to the Fourth Amendment. So here and there, I probably count the number of motions to suppress I've done on one hand, and I've been practicing law since 2007. So now you're talking about 12 years in, and I've been a criminal lawyer the whole time. So now, last but not least, we're going to talk about entrapment. Um, in a nutshell, just a quick definition of entrapment is, it is an affirmative defense. By affirmative defense, that means that the defendant has to bring it up as a defense, for it to come up. So it doesn't just automatically come in as a defense. So what entrapment means is, let's say, for example, I'm a regular human being walking down the street, minding my business. This random person comes up who happens to be an undercover cop and says, "Hey, can you hold this bag for me?" I'm like, "What? Hold this bag?" I'm like, "Okay, I'll hold it for you. I'll wait here till you get back. I'm just being friendly." I hold the bag, and 2 minutes later, I'm surrounded by cops saying, "Oh, you have the dope," and they arrest me, and I look in the bag, and it's cocaine. In that situation, I was minding my business, wasn't trying to commit a crime, and essentially law enforcement, through their own actions, led me into committing the crime. That is entrapment in a nutshell. Now let's change the facts. If I'm already a drug dealer and I'm out here looking for dope or something like that, and I have a propensity to do that, because my record's known and that's what I do. Or let's say I'm the one being investigated because I'm setting up a drug deal and I'm out here walking the streets and the dude walks by and says, "Hey, hold this bag for me or hold this bag of cocaine for me." And I'm like, "Huh?" And I hold the bag for him. And then the cops come. It's like, "Oh, well, boys, that's what he does. He wanted the cocaine anyway." It's harder to use the entrapment defense in that situation. You can still argue it, but we'll see how far that goes. Entrapment is a defense that may be invoked by a defendant who alleges that the government induced him or her to commit a crime. The vast majority of states and federal courts follow the subjective test, meaning that it's about what I would have done and who I am as a person being approached by the cops. This asks whether the defendant has a predisposition to commit a crime and likely would have committed the crime absent the involvement of the government. So if I'm Nino Brown and I'm already dealing dope, then that situation it wouldn't be much of a defense because that's what I'm predisposed to doing because it's what I do. A minority of jurisdictions follow an objective test, which only focuses on the conduct of the government. Like in other words, so it doesn't matter what I'm predisposed to doing. If I was minding my business, even if I'm the biggest dope dealer on the planet, if I was minding my business, somebody came up to me and said, "Hold this bag," and it happened to have dope in it. It's still all about what the cops did and whether I had notice of what it is, stuff of that nature. Due process is the third test. Defendants generally have been unsuccessful in arguing that the government's conduct is so outrageous that the prosecution is prohibited by the due process clause of the Constitution. Entrapment is an affirmative defense that must be raised by the defendant. So that is chapter 10 in a nutshell. We talked about the exclusionary rule. So what that means is when your rights are violated. Now we just talked about Fourth Amendment rights, but in general, if your rights are violated, there's one that the major way to remedy that is the first and foremost filing motion to suppress any evidence that was obtained illegally. That even applies to Sixth Amendment as well. Fifth Amendment, if you feel like you've been if any statement you made was obtained illegally, you were coerced or anything like that, the way to get rid of that evidence is to now file a motion to suppress. So that's the exclusionary rule. So what that means is any evidence that is illegally obtained, you have the right to suppress the evidence or try to make a motion to suppress. If your motion to suppress goes through, that means the evidence is excluded and can't be used against you. So that's like the court way of challenging your rights, challenging when your rights are violated. We're going to talk in later chapters about other things you can do when your rights are violated outside of just having the evidence excluded. So that's chapter 10 in a nutshell. Be good.